I'll start now, though, by thanking you both for your continued contribution to education in the industry, Samantha and Bernard. We are very grateful. The presentations are always very well received, whether it's just for case managers or lawyers to get their CPD points. There's always a lot of interest, and we always have a lot of requests for the presentations after today. So with your permission, at the end of today's presentation, we will distribute the PowerPoint and they show you the recording, but only with your permission.
Yeah, that's fine.
And anything you say today is off the record. Look, I think it is 5 past the starting time, so that's probably enough time for everybody. So we will start today with you guys. Locking at the end, if you can do the ICS presentation, that'd be great. Yeah, because we've got the screen already locked, so maybe come back in later. If you can hear me.
That's fine.
All right.
Yeah.
Okay. So we are today taking a closer look at medical negligence. The presenters are Samantha, Curro, Bernard, McAuley. I'd like to really thank them for the time to put this together. If there is any questions, would you prefer to take them at the end or during the course of the presentation?
Probably at the end, I think, would be good.
Okay. All right. So if anyone wanted to post questions, I'm happy to pass them on. And then at the end, we'll take questions as well. Now, I noticed that you're getting straight into it with an introductory page. I'm not sure where that page has gone, but just so that you get a little bit more background on both of you and your areas of special interest, would you mind giving us just a quick background how you have got to be an expert in this area? And then I'll pass over to you guys for today's presentations.
Yeah, sure. Well, look, I've just been practicing in the area of personal injury for some time now. I was admitted not that long ago in 2008, I think it was. And since then, I've been working in the personal injury field. So I think just through that experience, I've gained an understanding of a few different aspects of personal injury law. And my colleague Bernard similarly has been working in the personal injury field. Yeah.
Yes, and had experience working with the defendants, representing hospitals and doctors for a period of time, but also now representing plaintiffs in the medical negligence area.
Yeah, look, it's a very complex area. So without any more from me, I'll pass over to you guys to go through and illuminate us with your insights. And thanks very kindly for your contribution to education of everybody in the personal injury space.
No, you're very welcome. Thanks for having us. Look, medical negligence is quite complex, and we've just touched on a few of the basics today. And just as an introductory point for some people that may not be as familiar with it or not, so I've highlighted some of the elements of a medical negligence claim. So for negligence to be established at common law, you've got 3 main points you need to look at. So the defendant owes a duty of care. So for a negligence claim to come along, you've got to have the defendant breaching that duty of care, and that breach also has to cause some sort of harm The plaintiff bears the onus of proving this on the balance of probability. And in considering whether there has been a breach of duty of care, you've got to look at what standard of care is required by a doctor. Obviously, the plaintiff has to prove their injury or their loss as well. So it's a bit of work to do by a plaintiff. The way you sort of started a negligence claim is you have to commence proceedings in a court, and you do that with a statement of claim. There's a 3-year limitation period to commence proceedings for negligence. However, in some circumstances, the court can grant an extension. Patients can claim for things like loss of wages, past and future care, treatment, legal costs, care expenses. And the way lawyers usually go about proving these sorts of things is getting medical records. And it's extremely important to get good expert reports as well. And we'll talk about that a little bit later on. It's also good to understand that just because there's a poor clinical outcome, it doesn't always mean that there's a negligence claim. As a lot of the doctors here listening will know, many procedures have inherent risks. And if these risks have been adequately explained to the patient, the failure of the procedure may not constitute medical negligence. So the law that we look at here, the legislation that's important here, is something called the Civil Liability Act, 2002 in New South Wales. I'll be looking at divisions 2 and 3 of that act, which is sections 5B, 5C and 5D. Division 2 of the act deals generally with the duty of care that a defendant owes, and Division 3 deals with causation. So with section 5B and Division 2, the duty of care, the important parts here is to look at, and I'll just put this slide down a little bit more, is to look at whether the risk was foreseeable and that it wasn't insignificant. And with respect to causation, it's really important that there's a factual causation, to look at factual causation and the scope of liability. There is an exception that the court can look at when it's difficult to prove factual causation, and we'll also talk about that a little bit later on. So we'll go on to discuss duty of care. So as you can see, the term duty of care refers to the legal obligation to take reasonable care, not to injure or harm another person. And with medical negligence, we're obviously looking at the relationship between the health provider and the care that's owed to the patient. The law has determined that medical professionals owe their patient a duty of care, and this duty of care requires that the medical professional must exercise reasonable medical care in treating their patients and should use their professional skill and judgment to provide competent medical treatment and advice. There is a case, the name's a little bit difficult to pronounce, but I'll do the best I can. Stephanies, and I think it is, versus Brown, and Brown versus Newcastle Private Hospital Limited, trading as the Newcastle Private Hospital. It's a Supreme Court case. And it highlights that the duty of care owed by a hospital and a medical practitioner is independent of the duty owed by the other and cannot be delegated. So in this particular case, unfortunately, I'll call her Mrs. S. She had surgery, and the surgeon, unfortunately, when he was, I think it was bowel surgery, this particular one, and he left a lupus suture where it wasn't supposed to be, which caused a blockage and all sorts of post-operative complications, which ultimately caused her death. Now, the surgeon accepted responsibility for the majority of issues that arose, but also said that the hospital should be responsible by failing to ensure that observations and clinical pathway documents were completed. So the hospital sought to rely on something called an Ellis disclaimer, which is basically a document that she signed saying that any issues that came out resulted from the surgery of the doctor's responsibility, that she couldn't, you know, involve the hospital. However, Justice Schmidt in this case found that the hospital's duty was broader than it contended in this disclaimer. And Justice Schmidt concluded that the hospital had breached a duty of care to Mrs. S because its nursing staff had failed to record certain observations and failed to make the required observations and failed to take available steps to deal with her deterioration in accordance with its own clinical pathway guidelines. And they apportioned liability of the hospital at 20%. So it just shows that in these circumstances where there's a physician that's not necessarily employed by the hospital, that the hospital can still be at fault where the nursing staff haven't complied with the recommended guidelines and practices and procedures that should have been in place, particularly with observations and records. It was stated that the basis of a hospital's duty arises out of the hospital-patient relationship, and the scope of its duty arises out of the nature of the services which the hospital agrees to provide to the patient. So where treatment is provided in an emergency setting, for argument's sake, the hospital will be liable for the physicians which it employs. Where the physician attends the hospital, uses the services of the hospital for a private patient, both can be liable. So it's really important, I guess, for hospitals and physicians alike to recognise that there is that non-deliverable duty and that both can still be liable. And they've really got to ensure that adequate records are taken, particularly with the observation charts. It really helps with negligence cases, I guess, for a defendant to have really good records. The next thing I was going to discuss, moving on again, was the breach of duty of care. And we touched on breach of duty of care in that case, but I'll go on to it in a little more detail. So if a person breaches that duty by failing to exercise reasonable care, they will likely be found to be negligent and therefore liable for the injury or harm sustained. So common medical negligence claims may involve failing to provide diagnose a patient's condition. Symptoms can sometimes be overlooked, and this can sometimes be more so with the general practice. Sometimes medication can be prescribed that is incorrect, and that can be in a hospital setting where there are lots of people involved, or where a patient sometimes goes to multiple doctors and there's not clear records of what a patient's actually on. And that's why it's always good practice to tell somebody just to go to the one GP and not to doctor shop if that's possible. It also obviously can occur with surgery and or failing to warn a patient about the risks of surgery. So sometimes we also see it with general practice where general practitioners choose to treat patients for more complex illnesses where they may have been better off referring to an appropriate specialist. Or sometimes patients undergo treatment with undesirable long-term side effects. And that treatment may have been considered unnecessary in some regards. So many cases of medical negligence in hospitals can relate to treatment at emergency departments. We've seen that quite often. Also some maternity ward cases. Probably another big area, as I was discussing briefly before, medication errors. Sometimes we tend to see emergency departments can be staffed by doctors with less experience, and that can make them a bit more prone to negligence. And as you would know, there are cases where there have been midwives, for argument's sake, delivering a baby where an obstetrician should have been present. It can also, situations are also more prone to negligence where there are a number of treating practitioners or nursing staff involved. Patients have sustained injuries or even died when they've been prescribed medication that conflicts with another prescribed medication and checks haven't been properly performed, as I was touching on before. And this has at times been linked to the failure to properly communicate or properly complete medication charts and records. It's also sometimes linked to a lack of education of nursing staff with respect to medication. There was one particular case where there was an elderly patient that had undergone surgery, and I think it was a knee replacement, and he was given anticoagulation after the knee replacement because he developed some issues with his lungs, some clots in the lungs, and that settled. So there was a decision to change the anticoagulation medication. And unfortunately, between the doctors and the nurses, it wasn't communicated or recorded in the observations clearly enough, so that he ended up receiving 2 anticoagulation doses of different medications, and then sustained a severe brain hemorrhage and passed away. In that particular case, the coroner found that the correct procedure to cancel the prior blood thinning medication was not followed by both medical and nursing personnel, and that there was inadequate communication and handover about the change in medication between medical and nursing staff. He also found that nursing staff administering the blood thinning medications were not aware that the 2 drugs could not be given together because they had not received appropriate training and education. So I think that that's a very good point to take on for hospitals, and even general practice where they involve nursing staff, to ensure that there's good education and training, because hospitals will be responsible for their nursing staff. In the case of Queensland v Mason, this was a High Court case. The plaintiff presented with a severe asthma attack, elevated heart rate and blood pressure. Now, she was treated in the first instance by a paramedic, and this paramedic had reference to, I think it was a clinical practice manual, and the clinical practice manual said that he could treat her with an IV adrenaline, but it also cautioned in circumstances that this adrenaline could cause, I think it was hypertension, stroke, heart attack, or life-threatening arrhythmias. So because this lady presented with elevated heart rate and blood pressure, he chose to give her a drug called salbutamol, which is basically Ventolin, as far as I'm aware. And that's a short-acting medication that opens up the medium and large airways in the lungs. Unfortunately, it wasn't a great decision for the plaintiff, who ended up in a vegetative state with severe and irreversible brain damage. However, it went through a couple of courts. The trial judge held on this one that the paramedic had acted with reasonable care. It then went to the Court of Appeal, who decided that no, he didn't consider the CPM, and that was considered the standard of care. And then it went to the High Court, who said no, he actually did use his reasonable clinical judgment that an ordinary skilled intensive care paramedic might take, and that the CPM allowed for such an exercise in clinical judgment or departure from it if it was the best interest of the patient. So this particular case, aside from highlighting those points, also highlighted that the determining factor for a paramedic in terms of negligence was a little less than that of a doctor. There's another case which is important, Rogers v Whittaker, and I'm sure a lot of people have heard of this one, and that's with respect to breaching duty of care by failing to warn of inherent risks associated with surgery. So for those that don't know about this case, Miss Whittaker went in to have some eye surgery. She was blind in the right eye, I believe. And unfortunately, there was a 1 in 14,000 chance that she would become blind in her left eye if she proceeded with the surgery. She wasn't told that, unfortunately, so she proceeded with the surgery and she did become blind in that left eye. And in this case, Dr. Rogers was held to be negligent because he'd failed to warn her about that condition. And what they look at here is that a medical practitioner's duty of care involves warning patients of material risks, being those to which a reasonable person in the patient's position, if warned of the risks, would likely attach significance. So the courts have adopted the principle, really, that while evidence of acceptable medical practice is a useful guide for courts, it's for the court to decide the appropriate standard of care after giving weight to the consideration that a person is entitled to make his decisions about life, his or her decisions about life. And that's pursuant to the underlying common law principle for a patient to be able to choose. The patient's got to be protected from the occurrence of physical injury, the risk of which is unacceptable to the patient. And that's also highlighted in the case of Wallace v. Cam. Moving along to the second part of negligence, or proving negligence, causation. This isn't an easy thing to prove a lot of the time. To prove causation, a plaintiff must satisfy Section 5D1A of the Civil Liability Act, which requires that negligence be a necessary condition for the harm occurring. And this is known as factual causation. So it can't just be something supportive of increased risk of harm. So causation will only be satisfied if something would not have occurred but for the defendant's breach of the duty of care. The other part to proving causation is called the scope of liability, and that's identified in Section 5D1B, which requires the court to consider the scope of liability such that it is appropriate that the defendant's liability extends to harms so caused. In the case of O'Gorman versus Sydney Southwest Area Health Service, the Court of Appeal confirmed the common law approach to causation, that although an increased risk of injury caused by negligence may give rise to a possibility of causation, of itself is insufficient to establish the material contribution to an injury. So it has to be a necessary condition, not just an increased risk. So the plaintiff must prove on the balance of probabilities that the risk eventuates and is therefore causally connected to the negligence. In the case of Tabbitt v. Gett, this is another High Court case, the court held that the issue whether damage has been caused by a negligent act invites a comparison between how the plaintiff is after the negligent act and how they were before the negligent act. And such an inquiry directs attention to all the circumstances pertaining to the plaintiff's condition at the time he or she sought the medical treatment, which was not properly provided. The question of whether harm or damage has been suffered is bound up in the issue of causation, they said. If factual causation cannot be proved, then the plaintiff can go to Section 5D2, which is the exception to factual causation. The court in this regard looks at relevant matters such as whether or not and why responsibility for the harm should be imposed on the negligent party. And they do that by looking at established principles. Now, some of these principles were discussed in a case by the name of Jovanovski Bill Bergia. That case stated that exceptional cases arise when a plaintiff is unable to attribute to the defendant the harm suffered on the basis that scientific knowledge is inadequate, and where the negligence did increase the risk of harm eventuating. So there is that exception. In the case of Wallace v. Cam, Dr. Cam owed Mr. Wallace a duty of care which had been breached. The breach was caused by Dr. Cam's failure to warn Mr. Wallace of the inherent risks of the surgery, which was sustained by Mr. Wallace. However, the High Court considered the scope of liability test and found that if Mr. Wallace had been warned of the inherent risk, he would have proceeded with the surgery in any event. And on that basis, they found that Dr. Cam wasn't negligent. I think in this particular case, Dr. Cam didn't warn of the inherent risks of the surgery. However, the actual injuries sustained by Mr. Cam, or sorry, so I should say Mr. Wallace, was not one of those inherent risks, so they could not connect the two. There was another case, Old v. Miniter. In this particular case, the plaintiff underwent right ankle surgery, And after the surgery, he developed an infection. I think it was osteomyelitis, and he was treated with antibiotics. The particular ankle surgery that he had required the use of hardware. Now, 6 years after that surgery, he developed the same infection in that ankle again. And it was suggested that the surgeon should have removed that hardware, and that the hardware being there made him prone to this infection. Now, in this particular case, Judge Levy SC actually decided that the defendant did breach his duty of care, and by failing to manage the risks of subsequent infection, by allowing the hardware to remain, by failing to communicate the risk to the plaintiff, and by failing to maintain clear and accurate records. However, negligence couldn't be deduced as the plaintiff was unable to establish a causal relationship between the defendant's actions and the development of the further infection. I think they had numerous experts on this one that attempted to grow this organism and the like, but at the end of the day, they could not establish with a sufficient degree that there was a connection. And the court said that speculation is impermissible in a legal analysis for affirmatively finding that causation has been established. So it's a very difficult bridge to cross, and it's not an easy one, and you need very good experts. The importance of evidence confirming that procedures were followed in accordance with guidelines and protocols is also important. And this is highlighted in the case of Hawkins v South Western Sydney Local Health District. Here, a defendant hospital was found not to be negligent in response to an allegation relating to the provision of food to a plaintiff who was supposed to be on a free fluids diet. I think here the plaintiff had undergone quite a significant operation, so he was on quite a high dose of opioids post-operatively. And one of the things the hospital relied on, which assisted them in not being found negligent, were very good medical records, very good chart observations. And they also said that, look, he didn't have a very good memory because of his post-operative opioid intake. And I think the plaintiff actually admitted to that as well. So having very good records, I can't stress enough, is extremely important. In this case, the judge made specific reference to placing reasonable precautions, extensive procedures to check the suitability of meals, meal records, and that they reacted within a manner that was timely. So I guess helpful tips to sort of close my part of the seminar off for lawyers, just the significance of experts' reports and conclave preparation is very important, particularly to articulate with specificity questions in which experts should be directed. For medical practitioners, importance of good record, patient histories, especially when the patient has been to more than one general practitioner and they have a chronic condition. Telling patients that radiology and pathology isn't just accessible to all GPs. If they've gone to a number of GPs, they need to get those records from them. Having clear communication with patients, especially when there's non-compliance by a patient, noting it down in your records, because that can help down the track. If there is a claim made against you, if it's in your records that you made a recommendation and that the patient said that they haven't complied, at least you've made the recommendation. And as I said again, patients should be recommended or encouraged not to doctor shop. And I'll now hand it over to Bernie, who's going to discuss a little bit more about this topic.
Samantha, just before we get to
Yep.
Bernie,
Sure.
From the audience in regards to the time limit, does that also apply to a child who may have had surgery at the age of 14, but an 18-year-old feels that they might do a
Look, I believe a child can bring proceedings via a tutor, so I can check on that. But I believe that if something does happen to a child, usually if there's surgery with a child, there has to be some parental consent involved. So I believe that if something's gone wrong, then they can bring a claim within that time period with the assistance of a tutor.
If they choose not to, whilst they're determined.
Look, if they choose not to, I mean, the court, and they want to do it, and they do decide to do it later, the court will look at the circumstances, I'm sure, and look, it would be a case-by-case decision.
As a function of what happened in that time, are there things that would be ruled out or ruled in from your experience?
Look, it's such a difficult area that it really is a case-by-case basis with these things. If it is the fact that perhaps a symptom didn't show itself for a number of years afterwards, I would say that would be a better chances of getting through. But if there's significant issues at the start and it was just decided not to proceed, you may have a more difficult time of getting through. Yeah, but look, a lot of times with kids, it's also hard to tell how it's going to affect them until they're older. So it is a bit of a difficult one, and I definitely advise getting a barrister's opinion with those sorts of matters.
Okay, but the summary of that is that it's possible.
Yeah.
But is
it's always better to do it within that 3-year limit. Yeah.
Yeah. Okay.
Thank you. With children, it's good to get a barrister involved because it is a little bit more complex sometimes.
Yeah. Okay. Thank you very kindly.
No, you're welcome.
And over to you, Bernard, or Bernie, as Samantha refers to you.
Yes. All right. Thank you very much, Mark, the opportunity. I'm now going to look at some specific sections of the Civil Liability Act and how they relate in a medical negligence context. One of the most significant ones is Section 5.0, which is the standard of care for professionals. It doesn't apply, however, to failure to warn cases such as the one of Rogers and Whittaker, which are assessed on a case-by-case basis. So simply put, Section 5.0 sets out the standard of care for assessing whether the person's practicing as a profession, such as medical practitioners or nursing staff, have acted appropriately or have incurred a liability to the patient, the plaintiff. It's important to remember that Section 5.0 is a defence. It's a defence which a defendant can raise. And to do that, they will produce an expert report, an opinion, and also will serve evidence to support that the defendant has acted in accordance with competent professional practice. So that has significance for a plaintiff, is that it not normally be pleaded by the plaintiff in the statement of claim, and would only then have to be refuted if it's brought up, if it's raised by the defendant. So that may have issues in terms of the appropriate questions that a plaintiff asks, a solicitor asks in their letter of instruction, for example. So it's not to be confused with the elements which Samantha has already talked about in terms of breach and causation. Of course, there is some overlap. And of course, part of 5.0 is that expert opinion can be disregarded if it's irrational. And as I mentioned, in the court determining what the standard of care, the court will consider professional standards, codes of conduct, policies, procedures, and guidelines. So a plaintiff solicitor will be somewhat guided by the experts retained to serve those documents, and the defendants may have an advantage there in that sort of access. So we'll move on now to an interesting case involving Dr. Kalowski and Mesto. The plaintiff She underwent pelvic ultrasounds 2010 and 2011, which showed a fibroid, a non-cancerous growth. She then discussed her treatment options with her then doctor, Dr. Gabriel, a gynecologist, and some of the options included a laparoscopic hysterectomy, the removal of the uterus, and the various risks and complications were then discussed with the plaintiff. She then had a Mirena IUD inserted in 2013, but her symptoms and pain did not stop. Dr. Gabriel referred her to go see Dr. Kalawowski, the defendant in these proceedings, for a second opinion. And then he said to go ahead with the removal of the uterus. Unfortunately, she suffered an injury in the procedure, which was most likely occurred when the camera was initially positioned at the start of the surgery. I understand it's referred to as a blind entry, as there's no camera guiding the placement initially. So the plaintiff brought her claim and said, well, look, I've suffered this injury, and it was due to the negligence of Dr. Kalawowski. However, Dr. Kalawowski said that the plaintiff experienced a rare, but it was an identified risk and complication of the surgery, and the plaintiff had been warned about it, both by Dr. Gabriel and by him. And Dr. Kalawowski produced expert reports from gynecologist Dr. Jeffrey Reed and Associate Professor Michael Cooper, who had performed the procedure on a number of occasions. The plaintiff, however, served a report from a general surgeon, Dr. Truscott, who specialised in upper GI tract and emergency colon surgery. The court was more persuaded by the expert evidence of the defendant and ruled that the breach had not been successfully argued, and also the defendant was successful in raising the Section 5.0 defence. So that's also a lesson for plaintiff practitioners there in the choice of an expert for the individual, for the case. Now move on to Section 5H of the Civil Liability Act, which relates to informed consent, which is a very important section for in the medical negligence field. So a person, a defendant, a hospital or a doctor does not owe a duty of care to another person to warn of obvious risks unless the patient has specifically requested advice about that risk. It's a written law to warn the plaintiff of that risk, or the defendant is a professional and the risk is a risk of death or personal injury to the plaintiff patient from the provision of that professional service. So this is emphasises the importance of medical practitioners to obtain informed consent. Well, you might ask, how does that actually relate in the reality of a very busy medical practice? And obviously there is the balance for doctors to achieve, and the primary responsibilities to diagnose and treat patients, and where does the line draw in communicating what's going to happen and what level of detail that needs to be done. This is a very important decision in that field. And so Dr. Biggs and George went to the New South Wales Court of Appeal. Here the plaintiff was aged 63 and she had very limited English. She was a Macedonian migrant, and she had at the base of her skull, she had a tumour. And the operation took place at St. Vincent's Hospital in Sydney, performed by a team of surgeons there. And she was informed, and initially when she had the first few consultations, it was interpreted by a friend, and then at the hospital there was an interpreter there, but the interpreter wasn't there on each occasion. Unfortunately, during the procedure, there was a inadvertent division of the plaintiff's adjacent right 7th cranial nerve, which is the facial nerve, and this caused a right-sided facial palsy in the distribution of that nerve. So it's a significant injury for Miss George. And Miss George, as I said, she didn't always have the professional Macedonian interpreter there, but importantly, she agreed to have the procedure under the false understanding that the tumour was not benign, when in fact it was benign, and she also thought it was in her brain when it wasn't. So two very critically important facts weren't effectively communicated to the plaintiff in this situation. And so probably in two minds which way this case is going to go, bearing that in mind. So initially Judge Levy, he found for the plaintiff, and he provided for a 16-step process for doctors and hospitals to follow in obtaining consent. And some doctors, following the commentary following this decision, were critical of this process, and that it was divorced from the reality of a medical practice. It went up to the New South Wales Court of Appeal, where it was unanimously overturned, overturning the decision that the defendant, the surgeon, and the hospital were negligent in failing to warn Miss George of the material risk of the nerve injury associated with the surgery. Most of the case relates to the areas of the factual findings of the trial judge. But the decision importantly confirms that medical practitioners have a duty to take reasonable care to ensure that the material risks are conveyed to patients. The material risks, it rejects the suggestion that a doctor must take special steps to ensure a plaintiff understands, or that the plaintiff understands an interpreter. Part of a novelty to this case was that the Judge Levy criticised that the defendant did not call the interpreter, because as you can see, it was a crucial part of the case as to whether the plaintiff understood the material risk, and it was critical that the interpreter was not called, because he could provide some light on whether the plaintiff understood these risks. But the Court of Appeal was critical of Judge Levy's comments in that regard. I mean, you can see that it would be difficult for an interpreter to comment on the understanding of a plaintiff of the material risk, whether she understood the material risk. Okay, we'll now turn to the duty of care to third parties and whether they're owed. Well, they are. A duty of care may be owed to close family members of a deceased patient or an injured person. These are commonly referred to as nervous shock claims. In nervous shock claims, the individual must suffer a recognised psychiatric illness. Claim can be brought under the Compensation to Relatives Act as well. And also a duty of care is owed to a sexual partner of a patient, for example, who tests positive for HIV, but to whom the test result has not been communicated to the patient. And there was a case in respect to that. There's also the question as to whether a duty of care is owed to close family members of a third person harmed by a mental health patient. This really depends on its facts. Quite quickly, there was an important decision in this respect, the Hunter New England Local Health District in McKenna, which went all the way to the High Court and involved an individual, Mr. Pettigrove, had a long history of chronic paranoid schizophrenia. He was away on a holiday with his friend where he had an episode. His friend took him to hospital where he stayed overnight, and the decision was made for Mr. Pettigrove to be taken to hospital by his friend the next day, and so he was discharged on that basis. Unfortunately, Mr. Pettigrew killed Mr. Rose, and Mr. Rose's parents and family members brought a claim. Went all the way to the High Court. He was unsuccessful. The family members were, but I would stress that it could vary and could change the result depending on the facts. Now move to section 43A of the Civil Liability Act, which is it's a defence which hospitals, public hospitals that is, can raise. There is section 43A subsection 3 on the screen. Simply put, when exercising a statutory power, the hospitals need to do so in a reasonable basis. Now, a good case to consider is in seeing how this defence plays out is this case here, Smith and Pennington in Southwest Sydney Local Health District. In this case, Mr. Smith, he had 2 prior attempts at suicide, sadly, and the second attempt was by hanging in his parents' home, in the parents' garage. He was admitted to hospital involuntarily, and when assessed by the psychiatric registrar, he denied any suicide ideation and indicated that he wished to get on with his life and take financial responsibility for his actions. He was then seen the next day by a psychiatric registrar and a psychiatric consultant. And I should mention on the previous day, he was seen also in the presence of his parents. But anyway, on this day, when seen by the consultant and the registrar, they decided and approved that he could go on weekend leave from the hospital. And they made the decision not to impose any conditions on him, which they could have done under the Mental Health Act, such as restricting the plaintiff's access to alcohol, the ability to contact his former girlfriend, which were all noted as being triggers for him and stresses, and access to the garage of his family home, where he attempted the prior attempted suicide. So he's on his whole weekend leave, and he goes out drinking, and his parents tell the friends not to let him drink too much. Unfortunately, he made contact with his former girlfriend, and he attempted suicide in the garage by hanging, and suffered long-term severe brain damage as a result of this. So this went to the family. So Mr. Smith brought a claim against the hospital and was not successful, and they didn't establish the negligence, but also the hospital successfully relied upon the section 43A defence, and that the hospital was it acted reasonably in not imposing those conditions upon Mr. Smith. So now, look, I didn't want to end on such a sad note with that case. So here's a quote which summarises up well the complexity of medical negligence by the great Russian writer Leo Tolstoy, the writer of War and Peace. And I think it shows well that cases with a turn of facts can lead to very different outcomes. Thank you.
Tremendous, Bernie. Thank you very kindly. I will now open it up to the group, and hopefully we can see your faces there. If you can get a little bit closer. There we go. Any questions? I expect that the evidence is what the common law is all about, as opposed to the statutory aspect of workers' comp and motor vehicle accident. So I noticed you emphasise that both the hospital and the doctors should take what you probably referred to extraneous notes and detailed records of what happened, and that's, I guess, what you're referring to when you say that the facts of the matter, as the case turns on.
Yes, Mark. The doctors often joke with us that their notes they're not for the handover; they're for the lawyers. But there is an element of truth to that.
Yeah, well, you're writing for the record, I guess, and the problem I can imagine you guys would have is people are very, very busy, and quite often they don't take down notes, rushing to one place, and then equally people's memories aren't particularly reliable as well. Question just in terms of handwritten notes, what happens if only the writer can understand them?
I had one case like that, and what they did was they actually sent the notes back to that doctor and asked him to get it typed up. So I thought that was quite good, because it is really difficult to sometimes understand the notes, and particularly for purposes when you're going to court. And this particular occasion, it was really crucial what those notes suggested, because there were suggestions that it meant one thing and someone else was suggesting it meant another, and it was quite a crucial point. So what they did was they just sent it back to him and asked him to type up a handwritten, not a handwritten, sorry, a typed up version of what it actually said.
Any other questions? In the interest of time, if there are other questions, I'm sure people can contact you directly.
Yeah, that's fine.
Bernie.
With the other question that they had before, there is a 12-year long stop period. I mean, there's a bit with time limitation periods, it's not a straightforward thing. So if they do have any other questions, feel free to email sort of on a case basis, and it's not as straightforward.
No, it's a grey area, as referred to it as. Just quickly before everyone rushes off, we've got 3 minutes there, Locke. If you could just share your screen, and I'll just tie the presentation off by saying that thank you again for what it is that you brought today, Samantha and Bernie. Our contribution as medical legal providers and our software provider for the personal injury industry is a platform for exchange of documents, the booking of doctors, the request of clinical records, and Lockie, if you could just share the screen and show everyone what it is that we're doing as well for the broader industry.
Absolutely, thanks, Mark.
Thought you might have stuffed off.
So what Insurance and Compensation Services is working on is a range of software solutions to the personal injury industry. And this includes the flagship ICS Connect platform. And we have a range of additional products, including our telehealth solutions, some AI claims management tools. Sorry, what was that, Mark?
Are you doing a screen share?
I am. Is that not?
No.
Perhaps if we stop share.
There we go. Thank you. Ah, that was there. It disappeared. There we go.
Sorry, is that better?
Yep, perfect.
Yeah. So one of the key software solutions that we provide is ICS Law Connect, which is a fully customizable platform which assists law firms in their information gathering processes. And this includes modular service-based offerings and jurisdiction-specific communications and reminders. And there's also API integrations with government portals for evidence retrieval and external stakeholder logins. In the interests of relevance for today's presentation, I might move towards ICS Doctor Connect, which is a purpose-built software for small to medium-sized specialist practices and small to medium-sized medico-legal businesses to assist them in growing their business and improving their finance and billings aspect of the medico-legal process, which can sometimes be a significant pain point for those small specialist practices or those small medico-legal businesses. So ICS Doctor Connect provides a full calendar integration and management tool for these practices. And there's a complete finance and billing solution for specialists and automated attendance reminders for injured workers. And the platform also includes a secure document exchange system to manage your medico-legal and legal information. Some of the other tools that ICS is working on, we're working on some claims leakage and financial calculations tools, as well as some open source data analysis projects and some integrated telehealth solutions. And when the presentation of Bernard and Samantha is circulated after the seminar today, we'll include some information about ICS and ICS Connect and how to get some more information or get in touch.
All right, tremendous. Thanks, Locke. Any other final questions? No, all good. Look, finished right on the hour. What a perfect presentation. You must have done this before, guys.
Thanks, Mark.
Thanks a lot, Samantha. We'll be in touch. Thanks, Bernie.
Thanks a lot, Mike.
See you.
Cheers.
See you.
Everybody,
Bye.
thanks for coming.
Thanks, everyone. Bye-bye.
Bye-bye.